Welcome back to The Narrative. I'm your storyteller, Callistra Faria. Well, the story of the MV Harbour Master and Anderson Peters, world-class athlete, has been making the go-around in Grenada since last year. Last summer, we all remember the video of Anderson Peters in a fight with crew members of the MV Harbour Master, the party boat that was here for the carnival season. The matters stemming from that incident have been winding their way through the court system here in Grenada. And on Tuesday morning, the High Court here handed down a judgment in the matter. The side representing the MV Harbour Master owners made application to the court to have struck out a matter brought by Anderson Peters and his brother Kidan Peters, represented by what is virtually a dream team here, a legal dream team here in Grenada of Francis Alexis KC, Ruggles Ferguson KC, and Derek Sylvester. Now, the MV Harbour Master lawyers, represented by Ms. Nairi Alfonso of Trinidad and Tobago, as well as Delon Charles, based here in Grenada, asked the court not to dismiss the matter in its entirety, claiming that the matter was filed under wrongly, that the matter was brought against the MV Harbour Master, and the Ms. Alfonso is going to come on to explain to us the difference between REM and RES, and what all of that meant and what bearing it had on the decision of the judge to throw the matter out. We should also say that Derek Sylvester has indicated that their side, the Anderson Peters side, will be appealing this judgment. So I'm going to welcome now to the narrative Ms. Nairi Alfonso in Trinidad. Welcome to the program, ma'am.
Thank you very much for having me, Callistra. It's a pleasure.
And your side now claiming victory. You've successfully asked the court to dismiss the action that was being brought against the MV Harbour Master, and the judge has agreed with you that the matter was not properly filed and that the court has no jurisdiction to hear it. What does that mean?
So essentially what the court would have ruled, it ruled in favor of the application we made, to the effect that this was not a claim that the court had jurisdiction to hear. And the reason for that is that this, at best, is a claim arising out of some sort of brawl between crew members of the Harbour Master and the Peters brothers. But so that's the nature of the claim. What in fact was filed last August was a judicial arrest of the Harbour Master and a detention of the Harbour Master as security for whatever claims the Peters brothers had. We submitted and advocated from the very beginning that the court did not have jurisdiction to hear this matter, whatever those claims, the nature of those claims, on the basis that the Peters brothers, as said, at best had some sort of personal injury claim. I mean, it is alleged, um, but it did not have a claim against the vessel. And when you go and arrest a vessel, it's because you are saying, this vessel did me harm. And I need you to hold this vessel in the custody of the court for the period of time until I am satisfied, my claim is satisfied, or security is put up. In this case, security was in fact put up. Um, Financial security was put up and the vessel was released, but the underlying security remained um, in the hands of the claimants, the brothers, the Peter brothers, for the purposes of their claim. And our position is that claim could not be maintained in the manner it was filed.
What happens next? Has this matter been exhausted before the court now?
Well, in relation to the High Court, the judge has ordered that the parties put in written submissions in respect of costs. So the owners, being the victorious party as of this morning, they're entitled to their legal cost. They may also be entitled to pursue a claim for wrongful arrest of their vessel. That's another matter that the owners will have to consider. But immediately, they're entitled to the legal cost that they expended in A, defending the proceedings brought against the vessel, and B, the arrest of the vessel. So so cost, I think it's been adjourned to the 16th of November. So the court will make a decision, the judge will make a decision on the 16th with respect to cost.
And is it too early to tell? I mean, what sort of figures? I know you're probably crunching the numbers right now.
We
Can
will be crunching the numbers, and I'm only prepared to say the sums will be substantial. The area of law that was traversed in this case, I said, even by my standards, was very esoteric. Very, very, I'll have to say an esoteric point as to whether a brawl between crewmen and some claimants is it can be properly assigned. The blame for that can be assigned in an admiralty claim to the vessel itself. So just to correct you a little bit, Calissa. So we have two types of claims only. One is in rem against the thing, and in this case, the thing was a boat. And we have in personam against persons, and the Anderson brothers, I beg your pardon, the Peters brothers would have decided to go in rem against the vessel and to detain the vessel. They didn't sue anybody in person.
and so because in law the vessel is actually also considered a person, which is why they were also
Yes,
able to
yes,
arrest the boat and
yes.
uh, but went the wrong. You're saying they chose the. Did they have a target that they could actually bring the matter against?
Well,
Because it's
I'm sure the attorneys would advise them what was the appropriate target in August of last year. I still don't think there's an appropriate target. I said two people who decide to descend into fisticuffs. Um, you know, I don't really see how one can say I'm going to sue, because it's two sets of people that were in the brawl. Some of the people, well, the Peters brothers and the crew of the vessel. But I mean, if you are, as I am instructed, the protagonist of the fight, then I say I don't know why bring any action at all. But be that as it may, maybe that'll be ventilated in another place. Um, However, this was not the route to go, and certainly one of the things that should have been considered is the economic outfall of holding a commercial vessel, a vessel engaged in commercial trade. Obviously, there are going to be damages. Obviously, there are going to be financial damages sustained as a consequence of that act. So, as I said, those are the things that should have been considered in August last year, but were not. And the defendants, I mean, defendant owners have been very consistent from August last year that this claim was not maintainable. But, a year and more later, the court has concurred with us.
and so the laws, the areas of law that were considered on either side for this matter had to do with the Shipping Act, the Administration of Justice Act, as well as
Yes.
civil procedure rules. You used some of this to file your application to have the matter struck out for
Indeed,
want
I
of
mean,
jurisdiction, if that's the term.
yeah, the law wasn't in dispute per se. I think how that law was construed by the different sides was very, very important and very, very different. So while the claimants relied heavily on the civil procedure rules, well, civil procedure rules by their very definition and name, unfortunately, that's how you bring a claim. Not, it doesn't give you a cause of action. It doesn't even give you a grounding in law. It tells you how to bring it, right? So procedure is how to do something else that the law prescribes. So our position remained, as I said, unchanged, unaltered all through the period of time. The procedural rules cannot give you a cause of action. It cannot give the court jurisdiction. So yes, the procedural rules say, look, one of the admiralty claims is personal injuries. But you have to look at the context in which those personal injuries were sustained. And earlier today in the interview, I would have given the unfortunate examples of the personal injuries that I have done in my career. And it has been, unfortunately, for Trinidad and Tobago and its workmen, two oil tankers exploding and killing four people each. We would say, okay, the boat is the instrument that caused the death of these unfortunate gentlemen. So the the vessel exploded. The vessel took four lives on these two vessels took four lives on each occasion, and the vessel itself was the harm, the source of the harm. So there's a vast difference between those claims that I would have done for personal injuries and death, and people engaging, as say, in a fisticuff and a brawl on a vessel, on a party boat. The boat didn't do anything, but and if, just to give another example, had this boat hit um, a pier in Grenada or another vessel in Grenada, we would say the boat was the instrument of causing that damage, that resulting damage. And that was not the case. This was, say, the human beings not maneuvering the vessel, not doing anything with the vessel, getting into a fight with two other people. The admiralty jurisdiction just could not be invoked. And it is a pity that it was invoked.
But the matter is, the lawyers on the other side have said Derek Sylvester has said that they will appeal this matter, that it's not over yet. In fact, he's saying that, well, they won round one, which was getting the boat arrested and having the owners pay that 300,000 US in bond, which corresponded to the amount that they're asking for in their civil action. So he says they've won the first round. This ruling was not in their favor, but he's anticipating that on appeal, that a court will strike down the decision handed down by Justice Atty in St. George's this Tuesday. How confident are you that that decision would stand on appeal?
Well, there's no certainty in life except death. But but in terms of this particular aspect, these arguments here, I have full confidence in those arguments. Um, and those arguments are fundamental to the application of the admiralty jurisdiction. So one can never say that somebody should not appeal a matter. That's entirely up to them. They will evaluate the amount of cost that will be added onto already burdensome position. That is a matter for Mr. Peters and his brother, two Peters brothers, and their attorneys. Um, as I said, I'm not going to say, I've practiced for a long time. Matters are overturned all the time at the appellate level, whether it's Privy Council, whether it's Court of Appeal, whether it's CCJ. However, this particular point, as I have a heavy degree, a weighty degree of confidence that the arguments we put forward really it would be difficult to assail those arguments. They're based in law. We're not arguing over the law. We're using the same law. We're just construing it very, very differently. And the claimants, unfortunately, did not really bring case law to dislodge our position on the law. So I don't know if they're going to try and bring that at the appellate stage. That would be very, very strange to me, but that's a matter for them. But as I said, anybody can appeal. That's up to anybody.
And in layman's terms, they were saying the boat was responsible. Your response was no, the boat was not responsible.
No, the boat could not be responsible because I've given examples. If God forbid, the two Peters brothers had fallen off the ram because the ram collapsed and they were injured, we could say the boat was the instrument of that injury. If it is, I said, they were holding on to a railing or they're leaning on a railing and the railing had rusted through and they fell and they injured themselves, the boat or the lack of maintenance of the boat would have been the instrument of their injuries. If a fight ensues on board the vessel, the boat hasn't done anything. The boat is blameless. So you have to prove that the vessel was being maneuvered and there was negligence in the maneuvering of the vessel, or there was negligence in the management of the vessel. And really, as I said, fisticuffs between two group of men is not an instrument. The boat is not the instrument there. That's not an active participant in the fight. So I do think, as I said, they have a very, very uphill battle on the appeal. But as I said, every party is entitled to access the appellate part of your jurisdiction.
And there was loss of earnings. The harbour master remained in custody at Port St. George for a few weeks,
Yes, indeed.
and did not
Indeed.
leave Grenada until early September, about the end of the first or second week in September. So
That's my recollection, yes.
So there could be civil filings claiming loss of earnings as well. I suppose
Indeed.
there might be maintenance issues. The boat sat there. Was it maintained to the level it would have had the owners had full access and custody to it? Would all of those issues can all those issues be taken into consideration by your
Certainly,
clients
I
in
will leave it.
instructing you?
Yes, I will leave my clients to consider. We say early days, early hours, not days, early hours. Um, they certainly will want to examine their options as to whether there's whether they wish to continue this litigation. It may be that they're spurred on by the fact that they continue to be in the litigation and an appeal. But it would be open for them to consider starting fresh litigation based on this decision for wrongful arrest, and all of the damages, the cost of maintaining the crew, the cost of fuel and water and food and anything that goes with it, and the loss, more particularly, which could be very weighty, the loss of income to the harbor master because she was not returned to Trinidad and Tobago to continue her fixtures. So she was, if I understand, she was in Grenada in August for the purposes of your carnival, but she had fixtures in Trinidad to return to after your carnival period had finished. So, as I say, these claimants could be answering not only cost, but also a substantive claim in damages as well, and the cost of that as well once they are successful.
Well, I want to thank you so much for joining me here on The Narrative. Nairi Alfonso, attorney at law representing the MV Harbour Master and their owners. Thanks for being on The Narrative, ma'am.
Thank you very much for having me. It's been a pleasure. Thank you.
This is The Narrative. I'm your storyteller, Callistra Farrier, speaking there with Nairi Alfonso, attorney at law based in Trinidad and Tobago. And she is the lead attorney in the matter of the MV Harbour Master versus the Peters brothers, Anderson and Kidon Peters. Their lawyers brought a claim against the Harbour Master after a brawl last August, and the Peters brothers claiming injury, and they're filing a claim for $300,000 for damages. A judge in Grenada ruling based on an application put in by the attorneys, the lawyers representing the MV Harbour Master, a judge ruling that the court did not have jurisdiction to hear the matter as it was filed. This is The Narrative. More when we come back.